Welcome to this presentation about legal issues in workplace diversity. If you're a human resources professional, a big part of your job is going to be making sure that your company is abiding by the legal guidelines regarding how diversity in the workplace should work, and dealing with a lot of messy situations when people aren't doing what they're supposed to do. Let me introduce some of the key concepts related to this. First of all, the EEOC, the Equal Employment Opportunity Commission. This was established in 1965. It's a federal agency established to enforce federal employment guidelines. And this is a big deal. In 2013 alone, there were 93,727 discrimination cases filed with the EEOC, which resulted in almost $400 million worth of settlements by companies against two employees who had filed complaints. So if you feel like EEOC guidelines are not being followed in the workplace, what you need to do is file a complaint. Now, before a complaint can be filed with the EEOC, you have to seek some sort of internal resolution. In other words, you have to go through channels at the company, file a grievance, seek mediation, bring in an outside arbitrator, but there has to be some attempt made to resolve the issue within the company first. If a resolution can't be reached within the company, the employee can then file an EEOC complaint, at which point the EEOC begins an investigation to see if there's any merit to the case being brought. Three of the key concepts that you need to understand how the EEOC does its work is to understand what a protected class of people is, to understand what a bona fide occupational qualification is, usually just referred to as a BFOQ, and to understand the concept of adverse impact. I'm going to go through each of these concepts separately, and I'm going to start with protected classes of people. Legally speaking, a protected class of people is any group of people for whom protective legislation has been passed. So these are categories of people who historically have been discriminated against in the workplace, and there are now legal guidelines in place to protect people against discrimination based on race or color, sex or gender, national origin, age, disability, pregnancy, or religion and religious practices. Notice that sexual orientation is not yet on the list. At the federal level, it is not illegal to discriminate against somebody based upon their gender orientation. Now, local municipalities, states, cities, and so forth can expand categories of protected classes. So there are many places in the United States where discrimination based on sexual orientation is protected, but it's not nationwide. It's not something that's universal. Also, local municipalities cannot diminish the number of protected classes. So if the federal government has deemed that a group of people is a protected class, states or cities can't take away from that, but they can add new categories. Some of these are pretty clear, but some of them get a little messy. Religion and religious practices, for example, can be sort of murky. Can people be forced to work on certain days or during certain times of the days, depending upon whether it conflicts with their religious practices or not? Another gray area that's being fought out in the courts right now is whether Catholic institutions like colleges, universities, hospitals, and so forth can be forced to pay for health insurance that covers contraception, which is against Catholic doctrine. So right now, there are many cases in which the individual rights of a person clash with what is perceived to be the rights of a group, and the legal issues do get messy. So if you're thinking of going into the human resources business, be prepared to be preoccupied with these kinds of things all of the time. Something based on the previous slide that I wanted to mention too. Age is a protected class, and age discrimination protects people over the age of 40 from being unfairly discriminated against in the workplace. 40 may not sound like a terribly old age, but it is the age at which one starts to see discrimination. Employers tend to prefer younger workers because they cost less and they're less likely to be using health insurance and so forth. So there is a tendency to try to kind of move people out after a certain age. Anyway, 40 is the minimum age for protection. All right, let's turn to the concept of a bona fide occupational requirement, BFOQ. What this means is if an employer has a job requirement, let's say you have to have a college degree to work there, they have to be able to demonstrate that the job requirement is genuinely necessary for the person to perform the job. So another sticky human resource issue and a thing that complaints are often filed over is to determine if all of the things your company is requiring for positions are necessary. Because if they get challenged in a court of law and it turns out they're not bona fide occupational qualifications, then your company could be out a lot of money as a result of that. There's an unfortunate history in the corporate world of having these sort of bogus job requirements. You don't really need to have them in order to do the job, but it was a way of keeping people out. And the BFOQ is a way of trying to get around that. So I'm not asking you to memorize this diagram that you see in this slide, but it's kind of a flow chart that tells you whether a job requirement is legal or not. So does the requirement in some way refer to members of a federally protected class? If the answer to that is no, you go down to the next one. Has any laws expanded the definition of a protected class? And if the answer is no, then you go down further. If the answer to either of those is yes, and you have to say, all right, can you demonstrate that this requirement you have is a bona fide occupational qualification? Then if you can say yes, it's probably legal. If you can say no, it's probably illegal. So if you're hiring lifeguards at the city swimming pool, being able to swim should be a requirement for that job. And it is probably legal because certainly that's something you want in a lifeguard. On the other hand, if you want the lifeguard to have a college degree, well, there's no real reason that has to be the case. So that's probably an illegal job requirement. So what an HR person would do is to go down through this flow chart and try to determine whether something is legal or illegal. And this is essentially what the EEOC does when it's investigating a case of discrimination. Notice that there's a key concept in here, something known as adverse impact. So let me talk about that one next. Adverse impact occurs when a job requirement results in a consistent discrimination against members of a protected class. Now, the discrimination might be unintentional. Maybe you're using a requirement for a job and you're not even aware that it's discriminating against some group of people. But that doesn't let you off the hook. You need to determine whether your requirements are having adverse impact or not. And adverse impact is something that's legally determined in a very specific way. Adverse impact is determined through something known as the 4/5 rule. So if you've got two different groups of people applying for a job, and the percentage of people being hired in one group is less than 80% of those in the other group, then you do have adverse impact. So in this example, let's suppose we have 50 males who have applied for a job, and you hire 20 of them, and 30 females who have applied for a job, and you hire 10 of them. Well, you hired 40% of the males who applied and 33% of the females who applied. But 33% is more than 80% of 40%. So in this case, there would be no adverse impact. Even though you are hiring males at a higher rate than you're hiring females, legally speaking, the difference is not high enough that the courts would determine that adverse impact has occurred. Here's another example. Let's say you had 40 males apply for a job and you hired 20 of them, so 50% of the men got hired, and 20 females applied for the job and you hired 4 of them. So in this case, only 20% of the females got hired. Well, 20% is less than 80% of 50%. I'm sorry about all the percents. But what this means is the difference in the hiring rate is big enough that whatever requirement you're using is having adverse impact. So legally speaking, discrimination is occurring. So keep in mind, the HR professional has to be paying attention to who the employees are that are members of protected classes. You have to be aware of the requirements that are being used for jobs to determine if they're BFOQs, and you need to be able to determine if there's any adverse impact going on in your hiring procedures. And it's important to get this right. A company that's found guilty of discrimination can be dinged with quite a big fine. Here are some examples of some cases that have happened in relatively recent time. You don't need to remember any of these specific details. These are just examples of the kinds of settlements that have happened. But in 1993, the Shoney's restaurant chain settled a racial discrimination case for $132.5 million. It was determined that they had persistently discriminated against African American employees, and they agreed to institute an affirmative action plan over the next 10 years. In 1996, Texaco paid $176 million to 1,400 current and former African American employees based on the public airing of a tape of an executive using a racial slur. This was used as evidence that a toxic work environment had been set up at Texaco. In 2000, Coca-Cola settled a racial discrimination case for $192.5 million. Also in 2000, Nextel settled a gender, race, and age suit for $176 million. 2005, Abercrombie & Fitch settled for $40 million. 2010, Novartis settled a sex discrimination suit for $175 million. Merrill Lynch settled a racial discrimination case for $160 million in 2013. So the stakes are pretty high here. It's very important, for all kinds of reasons to get it right, but certainly it's in a company's best interests to follow the EEOC guidelines and not engage in any kind of discrimination at work. A very common and especially touchy area in companies revolves around gender discrimination and instances of sexual harassment. It's very natural for people to get to know each other and become attracted to each other at work. This is where a lot of people meet their future spouses and good friends and so forth. But it's also a situation that can be ripe for sexual harassment, and there are all kinds of guidelines that I won't get into right now. But basically, if a woman, usually a woman, but it can be anyone, feels as if he or she's been discriminated against because of their gender, or if they are not getting a promotion or a raise because they have not caved into the boss's sexual desires, this is a very serious complaint. Sexual harassment can also occur between coworkers. So if somebody asks somebody else out on a date and the person says no and has made it clear they're not interested, that's not sexual harassment. But if the person repeatedly badgers this person to go out with them, even though it's been clear that that other individual is not interested, This is sexual harassment. Sexual harassment also refers to things that create a hostile work environment. So if you're telling sexist jokes or posting lewd pictures or sending things around on email that you shouldn't be sending around, these could all be construed as sexual harassment. This is another area that human resources professionals spend a lot of time dealing with. So let's talk a little more about how one goes about managing diversity in organizations. One distinction that's important is the difference between surface level diversity and deep level diversity. Surface level diversity is the one we usually think of because we're usually referring to demographic information about people that's easy to determine. We're talking about things like sex, how many males and how many females work there. We're talking about race. We're talking about religion. Do we have the right amount of people from different backgrounds mixing together? Are we discriminating in some way against people of a certain demographic? Deep level diversity, on the other hand, is a little trickier. In this case, we're talking about the values and personalities of people being selected, and people that don't share those values are discriminated against. Sometimes colleges and universities are accused of lacking deep level diversity or a commitment to it because the perception is that conservatives are discriminated against when it comes to hiring, especially for faculty positions. And therefore, even though the college or university might be bending over backwards to be racially diverse or religiously diverse, there may in fact be some resistance to being diverse ideologically speaking. So the distinction between these two types of diversity can make managing true diversity tricky. And the legal guidelines that exist are almost entirely about surface level diversity. So as of now, there are no rules or laws that are being broken if it's shown that deep level diversity isn't being respected. So what you need to do is establish management strategies that are geared toward attracting diverse individuals to organizations and helping them advance their careers once they get in there. Sometimes companies are good at opening the doors and letting different kinds of people in, but once they're in there, they set up roadblocks and make it difficult for people to get ahead in the organization if they're not sort of a traditional white male kind of employee. This is also the area where affirmative action becomes an issue, and this is a widely understood concept. A lot of people are opposed to affirmative action because they believe that it's unfairly forcing companies to hire unqualified people over qualified people, and that is absolutely not the case. Affirmative action simply says if you've got a number of people who are qualified for the job, when you're making selections, improving the diversity of your workforce ought to be one of your considerations. And let's face it, in the past, a person's race, religion, or gender has certainly been used in the workplace to privilege white males. The idea now is that we're going to give some other people a shot. But we're talking about people who are qualified for the job, and this can be sort of a tiebreaker. In no case is a company being forced to hire unqualified people over people who are qualified. So to help companies get to where they need to be, diversity training has become very much a part of organizational life. Certainly here at Knox College, faculty and administrators and staff regularly have some sort of diversity training going on. And this is something that wasn't happening much even 5 years ago. So diversity training has a number of different goals. First of all, it's just to raise awareness of diversity issues and to kind of overcome the cluelessness with which many of us kind of go through life. We understand our little view of the world and we think everybody else is just like us, but in fact, they're not. A lot of times, there's a perception that employees are always overtly racist or sexist or hostile to diversity, when in fact, it's just people that are just kind of clueless, bumbling along, completely unaware of their biases, completely unaware that they're doing anything offensive. And so one of the goals is to kind of educate people to become aware of issues that they just haven't thought about before. And it also is about building some skills, helping individuals understand their shortcomings and figure out ways to get around them and to be better coworkers and employees and bosses. It's a very delicate thing. Most people don't want to go to diversity training. They'd rather be doing their jobs. And you have to take care not to alienate people by telling people that, okay, we know you're all a bunch of racists and we're here to fix that. Right away, you put people on the defensive. So you want to get people on board with the training without, turning them off right at the beginning. It's essential that the leaders send a strong message about its importance. If the boss tells you you've got to go to diversity training and then the boss rolls his or her eyes and says, I know, this is all a waste of time, right away you've undermined the entire reason for the training. So leaders have to be behind it and make sure that the employees take it seriously. There's something called reciprocal mentoring that also is a way to try to manage diversity. You match very different junior and senior people with each other. People tend to gravitate toward people that are like them. And so this is a way to sort of force individuals to have a sort of intimate relationship with somebody very different from themselves. And it can be very beneficial for both people. Some companies try diversity celebration days where they kind of trumpet their commitment to diversity and engage in activities. I'm not sure how useful these are. I think some of the other things we've discussed earlier are more important, but there's certainly no harm in trying diversity celebration days as well. Now, even if a company is doing everything right, they've got good diversity training programs, they have sound policies in place, they're very conscientious about adhering to federal guidelines to avoid adverse impact, you're still going to have some prejudiced employees. You're going to have some sexist guys, you're going to have some racist individuals, and dealing with these people, and it's especially difficult if they're a good employee otherwise, to try to bring them around. Because companies are ethically obligated to confront such behavior. If people are regularly making sexist comments or making racist jokes, even if they're not crossing a legal line, even if they're not breaking the law, they're creating a hostile work environment, and this is not good for anybody. So there are lots of ways to try to get at managing these prejudiced employees. One of the more common techniques is something called the calm questioning technique. You try to get people to think rationally about their comments. So you might start by saying, okay, if somebody has been brought in because they've been making anti-Muslim comments, let's say, you start by saying, well, are you saying you dislike this person because of his religion? Well, that's going to force the person to really examine, are they a bigot? Do they dislike Muslims? Have you ever worked with a Muslim? Have you ever worked with this individual? Do you think that this is a bad, stupid person? Has a Muslim done something in the past to hurt you personally? So you give the person a series of questions. You don't necessarily accuse them of anything, but you force them to think about their feelings about the individual who they're causing problems for, but also to think about their larger attitudes and to really examine if they are prejudiced and what the basis of the prejudice might be. So this is one of the things that managers are now trained to do, engaging in the calm questioning technique to deal with prejudiced employees.